just as the government has the ability to compel the production of information from citizens, citizens have the ability to compel the production of information from the government. And the primary way this is done at the federal level is through the Freedom of Information Act. The Freedom of Information Act is part of the Administrative Procedure Act, and it starts with the assumption that government documents generally must be made available. That is the default assumption, that documents belong to the public and that they should be made available unless there's some compelling reason that they shouldn't be available. Now, the federal government receives a lot of Freedom of Information requests each year. It's up to now more than 800,000 requests per year. And there is a huge backlog. There's currently a backlog of more than 200,000 requests. And all of this is growing pretty rapidly, as you can see over time. Just about a decade ago, there were only about 600,000 requests, and now that number has increased by more than a third over the course of the last decade, and this only goes through fiscal year 2017. So making a Freedom of Information request is very easy. Once again, the internet has made it extremely easy to do. Anyone can make a Freedom of Information request. It doesn't even need to be an American or anybody living in the United States. Non-citizens or anyone around the world can make a Freedom of Information request. Their request has to reasonably describe the information requested. The person making the request may not know the name of the actual document or the file, but as long as they reasonably describe it, of course that's an ambiguous term, but nevertheless, if they do that, then they should be entitled to the information that they're looking for. Now, the law also says that a Freedom of Information request must not require an unreasonable effort. So you, for example, can't say, well, we want every document the federal government produced in fiscal year 2015. Now, this requirement, however, is interesting to me because the requirement that it not have unreasonable effort stems mainly from the fact that once upon a time, Freedom of Information requests require the production of hard copies of actual documents, and so there was lots of photocopying involved and paper and so on and so forth. Nowadays, of course, most government documents are electronic, and it would seem to me that it's not unreasonable to turn over every single thing an agency has in electronic form. I haven't seen any studies or anything, but I would anticipate that the move to electronic documentation makes more Freedom of Information requests reasonable and therefore widens the scope of the Freedom of Information Act. So if you want to make a Freedom of Information request, it's extremely easy. Just go to foia.gov/how-to.html and fill one out. So if there's something you're interested in related to your job or that you just want to know, check it out. What can you request? Well, you can request just about anything the government has. Documents, emails, video, audio, whatever they might happen to have. But before you receive it, they may remove information to protect the privacy of those individuals who are named if that's relevant. So when the government receives a request, the agency that gets the request by law has 10 business days to decide on how to respond. There may be reasons to turn down the request, but they have 10 business days to make their decision. Now, this can be extended to 20 days in, quote, unusual circumstances. And those that are denied a Freedom of Information request have to be notified of the basis of the denial, and they have to be notified that they do have a right to an appeal. Now, the delivery of documents is not required. This is kind of an annoyance to some individuals. The requirement is simply that the documents must be made available for inspection. So sometimes in responding to Freedom of Information requests, the agency will actually require the person making the request to come down to the agency and examine the physical copies of the documents. Typically they can make notes, but they can't take the document or make photocopies of it. Now, although the law says that the agency has 10 or 20 days to respond to requests, this deadline is often missed. It's missed quite frequently, and in fact, as we mentioned a moment ago, there's a backlog of more than 200,000 cases. This, of course, led to a court case. This was not decided by the United States Supreme Court. It was decided by a lower court, Open America v. Watergate Special Prosecution Force in 1979, by the D.C. Circuit Court of Appeals. In this case, Open America wanted some information regarding the Watergate affair, and they had waited much longer than the 20 days required under the Freedom of Information Act, and so they filed a lawsuit. But the D.C. Circuit Court refused to enforce the 20-day deadline. They said that if they were to give Open America what they wanted, this would simply give preferential treatment to those who sue. So anybody who sued, they could make sure the 20-day deadline was enforced, but those who didn't sue wouldn't, and this would be unfair to those who didn't sue. This is a very strange decision because, of course, anybody who sues is going to get preferential treatment in any area of law, and I've never really heard of a court making a decision on this basis, but nevertheless, that's what they did. And no other court has disagreed with this decision. It wasn't overturned by the United States Supreme Court, so this is effectively the state of the law as it is today. So what you have is a 20-day deadline by law, but it's completely unenforceable. Now, President Obama was criticized for dragging his feet and his administration on Freedom of Information requests. In 2009, Obama, like all presidents, declared that he would be the most open administration in history. But in 2015, the Associated Press did an extensive study of the Obama administration's response to Freedom of Information requests, and what they found was that a full 39% of them were simply denied, or they were censored so significantly that the document that was produced wasn't really very useful. So a large proportion of the requests were simply unresponsive. And this was a new record in 2015, breaking his old record from previous years. In addition, under Obama, he eliminated 9% of the employees who responded to Freedom of Information requests, so the backlog grew larger. The study detailed just one case. You can find many other examples online, but the AP, Associated Press, once upon a time asked for a document on the deal that the Obama administration had reached with Iran on sanctions. They waited 9 years for the document to arrive, and when it did, it was almost entirely redacted, meaning it was almost completely useless. So President Trump, of course, also promised that he would be one of the more open administrations in history, but of course that simply hasn't been true. By all accounts, things are getting worse under the Trump administration regarding the Freedom of Information Act. And although I don't have statistics on the number of requests, we do have statistics on the number of lawsuits that have been filed against the Department of Justice. This indicates unhappiness, obviously, with the administration's responsiveness to a Freedom of Information request. And as you can tell, since the Obama administration, the number of Freedom of Information lawsuits has increased dramatically. So things were not good under Obama, and they haven't gotten any better. Some Freedom of Information Act requests are turned down simply because they fall into one of the categorical exemptions outlined in the law. These are particular kinds of documents that agencies are simply not required to turn over. Now, I won't go over them in great detail, but your book does indeed list them. They include documents related to national security, documents related to critical infrastructure. This was added after September 11th. Documents related to personnel rules and practices are exempt, as are specific information that is exempt in statute. So many laws contain specific kinds of information that should not be released under the Freedom of Information Act. Trade secrets and other financial information are also exempt if the government, has a document that would reveal a trade secret. Inter- and intra-agency memos are not subject to the Freedom of Information Act. Personnel files and medical files are also exempt, and law enforcement records as well. So there's a significant list of exemptions that includes the regulation of financial institutions. And geological information, for some reason, is also exempt. I'm not quite sure why, perhaps national security as well. Now, your book has several cases on this, but it's important to keep in mind that just because information is exempt does not mean that an agency has to keep it secret. They certainly can choose to release exempt information. It's simply that they're not required to do so. But, and it gets a little more confusing, there are other laws that prohibit the release of certain information, such as the Privacy Act, and your book talks more about the provisions of the Privacy Act. Some administrations, of course, are more open than others, as we just talked about. Your book, as I mentioned, has 3 different cases related to the exemptions to the Freedom of Information Act. They are Milner v. Department of Navy, U.S. DoD versus the FLRA, and the National Archives versus Favish. I encourage you, as usual, to check them out. One question that's gained currency in recent years is the question of privatization and the Freedom of Information Act. As you probably know, privatization is growing. The government is outsourcing more of its duties to private agencies. But the Freedom of Information Act only applies to governmental agencies. And so one question is information that is generated by private companies as part of a government contract subject to a Freedom of Information Act request? Your book has a case on that subject, Forsham v. Harris, which indicates the answer may be no.